Welcome back to Oba's Trending Gist. Today, we are diving into a hot-button issue in Nigerian politics: the eligibility of former President Goodluck Jonathan to contest the 2027 presidential election. This question has been on many minds, especially with recent constitutional amendments. We have a clip from Dr. Monday Ubani, a senior advocate of Nigeria who offers a crucial legal perspective on this debate. He features on Arise News, so let's watch what he has to say about it. Take a watch.
I want to say this with a caveat that my personal opinion, the legal interpretation of the eligibility of the former president clearly is not a validation, whatever opinion that I express is not a validation of whether I want him to run for the presidency of Nigeria 2027. Now, I'm only looking at it from the legal perspective. You are very correct that as far back as 2022, even after the fourth alteration of the Constitution, there has been a judicial pronouncement that affirmed the fact that President Jonathan is clearly eligible to run. We recall that in 2010, he came in to complete the tenure of the late Musa Yar'Adua's presidency, and he was naturally sworn in. But it is not by election, it's clearly by disposition of the law. Complying with Section 146 of 1999 Constitution is by operation of law. It was in 2011 that he ran for a proper election in which he won, 2011 to 2015, and he was sworn in. I think even in 2015, when he wanted to recontest, somebody went to court. That is this in Joko. That went to court here in Abuja, FCT High Court. And one Justice Oniga, Oni Sangia, yes, one Mudashiri, ruled that the president then is eligible to run, and that there's nothing that has actually that's going to stop him from running, that the former oath that he took in 2010 was not by virtue of election, but by virtue of succession, that he succeeded the former president. And so there is nothing that actually we should preclude him from running. But there was an alteration of the Constitution, what we call the fourth alteration in 2017, that came into operation in June in 2018. Now, by virtue of decided authorities by the Supreme Court, law at anywhere in the world is prospective, is not retrospective. You don't enact a law and begin to take away vested right or existing right or impose new obligation, when the person at the time that situation took place was not aware of the existence of a law. So every law is prospective, every law. The commencement date of any law is from the day it is signed into law. A bill is signed into law, it becomes operational. And so if the law does not expressly, include the provision that it is retrospective or retroactive, you cannot in any way interpret the law to be retroactive. So if there was an amendment in 2017 that came into operation in 2018, how could that law be applicable to vested right that took place in 2010 to 2015? It is clearly, impossible for such a situation to occur. So my view is that President Jonathan is clearly eligible under the 1999 Constitution to run for 2027. As I said earlier, I'm not in any way validating his choice as a president. I'm only stating what the law has said. And the law itself is that he is eligible under the 1999 Constitution, despite the provision of Section 137, subsection 3, that came into existence in 2008.
That was Dr. Monday Ubani breaking down the legal intricacies surrounding former President Jonathan's eligibility. Let us simplify his points. Dr. Ubani clarified that his opinion is strictly a legal interpretation, not a personal endorsement of Jonathan's candidacy. He highlights that as far back as 2022, even after the Fourth Amendment to Nigeria's Constitution, there was a court ruling that confirmed Jonathan's eligibility. He explained that Jonathan first became president in 2010, not through an election, but by law to complete the term of the late President Umaru Musa Yar'Adua. This was in line with Section 146 of 1999 Constitution. He then successfully ran and won the 2011 election, serving his full term until 2015. Even in 2015, when he sought re-election, A case was brought against him in the FCT High Court challenging his right to run. The court, however, ruled in his favor, affirming his eligibility. So, the core of Dr. Ubani's argument rests on a fundamental legal principle. Laws are generally prospective, meaning they apply to future events, not retrospective, meaning they don't apply to past events. The Fourth Amendment to the Constitution, which brought in Section 137, subsection 3, a key section in this debate, only came into effect in June 2018. Therefore, Dr. Ubani argues that this 2018 amendment cannot be used to invalidate or take away rights that Jonathan had acquired or exercised before the law was enacted. In his view, President Jonathan's previous tenures, particularly the one from 2010 to 2015, happened before the current amendment became operational. Based on this, Dr. Ubani concludes that Jonathan is legally eligible to run for the presidency in 2027 under the 1999 Constitution. Now, let's offer a critical take on this complex issue. While Dr. Ubani's legal argument about the non-retrospective nature of law holds significant weight, the political landscape and the spirit of the constitutional amendment add layer of complexity. Section 137, subsection 3 was specifically introduced to prevent individuals from exceeding a two-term limit for the presidency, especially those who might have completed parts of a previous president's term. The intention was to ensure that no one could essentially get a third term by first completing a partial term and then running twice. Although the Supreme Court has often upheld the prospective application of laws, the unique circumstances of Jonathan's previous ascent to power and the explicit nature of the 2018 amendment make this a tricky legal area. Some legal experts might argue that even if the law is prospective, it could still apply to future actions like contesting in 2027 by defining past period of service in a new light. The phrase KEYAMO wants PDP on fielding Jonathan on the news ticker during the video itself highlights the intense political implication. Any move by the PDP to field Jonathan would undoubtedly face rigorous legal challenges, pushing Nigeria's judiciary to make a definite interpretation that could set a major precedent. It's a classic case where legal technicalities meet political intent, and the outcome will significantly shape Nigeria's future elections. So, the debate over Goodluck Jonathan's eligibility for 2027 presidency is far from over. Dr. Ubani's analysis provides a strong legal foundation for his eligibility based on the non-retrospectivity of laws. However, the wider political context and potential alternative interpretations of the constitutional amendment means this will be a story to watch closely as we head towards 2027. Thank you for tuning into Ubas Trending Gist. Don't forget to like, share, and subscribe for more insightful discussions.